All right, so welcome. This is what judges, attorneys, and prosecutors need to know about how VAWA confidentiality impacts discovery in cases involving immigrant survivors. And our learning objectives today, really we want to ensure that immigrant victims
Next slide, please.
We want to ensure that immigrant victims are afforded the protections that Congress intended. So in order to do that, we want to make sure that you folks understand and can identify immigrant victims who may be eligible for immigration relief. And if you're a victim advocate or an attorney, that you're asking the right questions to make sure you can identify if these folks are entitled to relief. And if they are eligible, do you then understand VAWA confidentiality? Same thing if you're a judge, do you understand confidentiality? If you're a lawyer or working as a prosecutor and you receive a discovery request, we want to make sure that you can properly advocate for the protections that are consistent with VAWA confidentiality. And if you're a judge, we of course want to make sure that you understand VAWA confidentiality and you can craft orders that are consistent with the protections that are afforded by Congress to protect the victims. And finally, we want to give you some best practices, address discovery requests that you may see in family, criminal, and civil cases.
Next slide, please. So we want to thank both the State Justice Institute and the Office on Violence Against Women for supporting this webinar. The opinions, conclusions, and recommendations that you'll hear today are mine, Jane Anderson's, and Judge Ware's. Next slide, please. Oh, and one other thing while you're going to the next slide, I just want to note, if you could please type your questions in the chat. We're not going to use the question and answer function. It's easier for us as presenters to keep an eye on just one place, the chat. And so we're going to encourage you to type your questions as we go. Any of the questions that we can answer as part of the presentation, we'll work into the presentation. Anything we don't get to, we'll follow up with the group, with everybody who registered in writing. And I just also want to note before I forget, we're going to do a follow-up email that Gwen Szabo, our Dean's Fellow, is going to help us with. That will include a publication that we can't put on our website, but we can distribute. So we're going to include a publication that you'll get as an attachment to an email in the follow-up. So let me just start. I'm Leslie Orloff. I know I've been yammering. I direct the National Immigrant Women's Advocacy Project at American University Washington College of Law. I started my career as a family lawyer. I was involved in writing not only the VAWA immigration petitions, the self-petition T visa and U visa, but I was kind of the lead negotiator working with Congress, bipartisan Congress, to draft the VAWA confidentiality provisions originally in '96 and each of their updates since then. So really excited to be here, and I'll turn it over to Judge Ware to introduce herself.
Okay, hi, I'm Mary Weir. I am a judge in Kansas City, Jackson County, Missouri. I'm a state court judge. My first job out of law school, I worked as a law clerk actually in the division I'm sitting in right now. And the judge I worked for, she actually assisted in writing the Adult Abuse Act in the state of Missouri, which created the orders of protection. I also worked as a public defender, so I did criminal defense. I spent 12 years as a civil legal assistance grantee attorney, working with some of the shelters here in Kansas City, Jackson County. The grant was through Hope House. I was a contract attorney, and I represented folks in custody, orders of protection, domestic violence victims in custody, orders of protection. And that's where I first met Leslie, who started teaching me all this that I needed to know about immigrant victims and immigrant rights. And in 2013, I was appointed by the governor of Missouri to my current seat on this court. And from there, Leslie brought me in to start doing trainings as a judge. So I'm happy to be here today, and glad you all could join us.
Good morning, everyone. I am Jane Anderson. I'm an attorney advisor with Equitas, and Equitas has been a proud partner of NewOps for many years, probably before I even started, which has been a while. We love being able to add our expertise from the point of view of criminal prosecutors. So I am a former assistant state attorney, having practiced in Florida's 11th Judicial Circuit, which is Miami-Dade County. My career included focusing on domestic violence, sexual violence, and eventually co-founding our human trafficking task force, which turned into a standalone unit. So as a prosecutor, I advocated for victims that I was representing their interests. I advocated for them to receive U visas and T visas. And as the chief of litigation of our misdemeanor domestic violence unit, I was actually a certifier on cases of U visas. And now I provide training and technical assistance to prosecutors and allied professionals around the country. And one of the most common topics I have asked of me is, can we get more training about what these mean, how we can protect victims from motions to compel, and how we can then strategize how to talk about it in court. So hopefully I'll be able to share some of that with you all today.
Great. So, Judge Ware?
Yeah, hi. So we want to get an idea of who's with us. So if you can identify yourself. There's a poll up, so.
Great. And those of you that are clicking other, if you could type what other is in the chat, that would be useful. Since 60% of you are clicking other, it looks like. So we have some judges and court staff, some prosecutors, domestic violence family lawyers, and other.
A lot of others.
It looks
Lots
like
of
immigration
attorneys in the chat, guys. Welcome.
Yeah. Legal advocates. Great. Okay. Mary Kate, I think I can take the slides. I see how to do it, so I'm going to try that. Thank you for the poll, Mary Kate. Okay. So as we get started, the first thing we want to do is, just as some background, I want to talk about this is a great tool. If you when you receive this in the materials, and Gwen will make sure we've got this in the materials, which I think we do. It's when you get the PDF, if you click on the circles, it takes you to the forms. And if you click on U visa or VAWA or T visa, it'll take you to the current webpage at the Department of Homeland Security. So it's very good, but I use this to kind of as a way to talk about when we talk about VAWA confidentiality and discovery, the places we're talking about, the people on this list that get VAWA confidentiality protection are the trafficking victims who have filed a T visa or in the process of filing a T visa, or who have received or in the process of filing for continued presence. It also covers VAWA self-petitioners and VAWA cancellation and suspension in immigration court. These are always victims of domestic violence whose abuser and child abuse, whose abuser is their US citizen, spouse, parent, or child, over 21-year-old child, or their lawful permanent resident spouse or parent. And in the VAWA self-petitioning cases and in U visa cases, the parent can be a step parent. So it includes step parent relationships. Also covers U visas, which are a whole range of criminal activities that I'll show you in a minute. That this is where if you're a domestic violence victim and you're a sexual assault victim and your perpetrator is not your husband or your parent or your child, but is somebody else, or is your husband, parent, or child and is not a U.S. citizen or lawful permanent resident, there's a whole range of criminal activities, including trafficking, that's covered by the U visa. So those are the 4 that get VAWA confidentiality protection. Asylees have an independent form of of confidentiality protection that is similar to, but not quite as strong as the VAWA T and the VAWA confidentiality protections. And so it may be possible if somebody tries to discover an asylum application in a criminal case or a family court case, the same things we're arguing now may work, but the protections are different legally and may vary legally. But I'm mentioning it because there's those protections, and Gwen will include the link in the materials that we follow up with. There's a link to where USCIS explains the asylum protections as well, in case that comes up. And the last group we're talking about are SIJS children, who are children abused by a parent anywhere in the world. It could have happened in the home country. It could have happened in the US. Children who are abused, abandoned, or neglected. Now, these groups do not have discovery protections in their immigration case. However, if an SIS child is included in their mom's VAWA application or their U visa application, the VAWA confidentiality protections that we're talking about today apply to the person and every immigration case they ever file after they file the VAWA confidentiality one. So it covers, so an SIJS child who's included in a VAWA application, a T application, or a U application will have VAWA confidentiality protections just like they would, based on their other type of immigration case. So that's the reason, that's the point I wanted to make on this slide here. And this is a list that includes all of the U visa criminal activities and the activities, the child abuse, abandonment, and it includes the activities that Department of Homeland Security has recently clarified are substantially similar: hate crimes, elder abuse, child abuse, disabled adult abuse, and video voyeurism. So we're gonna start by showing you just very quickly how easy it is to identify in the cases you see whether a survivor you're working with may be eligible for one of these forms of immigration relief. And the first one I'm going to talk about a little bit more is the VAWA Selfpetition. These are where the abuser is a U.S. citizen or lawful permanent resident, as I explained a few minutes ago, and it can include the VAWA Selfpetition, that's a case that the victim files herself. It could include what's called a battered spouse waiver. Those are cases that the abuser originally filed immigration papers for the victim, and she got her papers based on his case. And there's a requirement that she stay with him for, like, if the victim comes to you and says, I have to stay married for 2 years, chances are you're looking at somebody who's eligible for a battered spouse waiver case. But it's very similar to the VAWA Selfpetition, will be the same kinds of relationships. And then the protections from removal are VAWA cancellation. So these are things where the abuser is a U.S. citizen or lawful permanent resident, usually spouse or parent.
Okay, so we're going to talk about U visas just really simply. To qualify for a U visa, the victim has to be a victim of qualifying criminal activity. That's really that list that Leslie just showed you. In addition, they have to have been, are currently being, or will likely be helpful in the future. And that can be helpful in the detection, investigation, prosecution, conviction, or sentencing. So it's important to recognize those are all in the disjunctive, meaning you can have been helpful in the past at the detection of a crime. And that's the past, and it's only the detection, and you would qualify. You have to prove, and this is usually the heavy lifting of the advocate or the immigration attorney, not the law enforcement prosecutor piece, but they do have to demonstrate that they suffered a substantial physical or mental abuse as a result of the victimization of that criminal activity, which is marked on the U visa certification. Usually this one isn't a hard one to overcome, but they have to have some information about the crime. It has to have occurred in the US or violated US law. So when it comes to discoverability under VAWA confidentiality, that's really where we're going to go for the rest of our time here, is talking about some of the times where it may be discoverable in criminal or civil matters. Often if you as the prosecutor or law enforcement are the one that's certified, then it most certainly will be discoverable, just that certification itself, and not much beyond that.
Jane, before we go to the next slide, I thought there's a quick question that I think you might want to answer here. And
sure.
If what happens if the survivor is helpful to law enforcement, but the prosecutor decides not to press charges?
Yeah, absolutely. So this is where, the rubber meets the road most of the time. And so there is no requirement that charges be filed or that even an offender is identified and arrested. So the example I like to give of this victim-centered analysis is, okay, what did the victim experience? Did they experience that criminal activity? This isn't a question about really, did I get a conviction out of it? So an example might be a victim who experienced a sexual assault, went and got a sexual assault kit examination, had forensic DNA collected, and there just never was a CODIS hit, and they never did identify the offender. That person was helpful in the investigation. Now, they couldn't ultimately identify someone, but this person would qualify because of their experience as a crime victim.
Great.
So the next one is the T visa. To qualify for a T visa, it's not as broad. It's only for victims of what they call a severe form of trafficking in persons. That can be a little off-putting. It's no sort of extra requirement that it's trafficking plus something else. It's just in line with the TVPA's language and their definition of human trafficking. They have to be physically present in the US on account of the trafficking, which could include the investigation into the trafficking. And they must comply with reasonable requests for being helpful. There are some exceptions for T visas if someone's under the age of 18, or if they can demonstrate that they'd have some physical or psychological trauma that would impede this ability to cooperate. And that usually requires some sort of medical documentation. The big difference between U visa and T visa is that a T visa, you don't necessarily need a law enforcement declaration to accompany the application. It's very much encouraged, but you can apply without it. Whereas the U visa, if you don't have a certification from law enforcement, it's do not pass go, do not apply. And again, we're going to talk about when this declaration, if signed by law enforcement, is discoverable. It may be in almost certainly in a criminal case, and we might look at it through some other lenses as well.
Great. So now I'm gonna read you. We're going to be coming back to this case scenario a couple times during the presentation, but I'm going to show you what this particular, like how easy it is to decide, to see whether somebody may qualify for one of these forms of immigration relief. So Clara met Eduardo, a lawful permanent resident, when he came back to his hometown to visit his family in El Salvador. Eduardo started dating Clara, who was raising her 9-year-old son, Miguel. Eduardo and Clara get married. After Clara became pregnant and gave birth to their baby girl, Lupe, Eduardo decided to bring Clara, Miguel, and Lupe to the US to live with him. When they arrived in the US, Eduardo took Clara, Miguel, and Lupe's passports and became physically and sexually abusive of Clara and abusive of Miguel, who tried to protect his mother from Eduardo's abuse. Eduardo also physically beat Lupe when he said she misbehaved. Within a year following their arrival in the US, Eduardo forced both Clara and Miguel to work for his family business and never paid them for their labor. One night, when Miguel was 13 and Lupe was 5, Eduardo's rage led to severe beatings with a belt of Miguel and Lupe. When Clara intervened to protect the children, Eduardo strangled her until she passed out. The neighbors called the police for help. Clara talked to the police when they arrived. The police arrested Eduardo for attempted murder and child abuse and took Clara to the hospital and placed the children in the care of the state. So,
looking at this, if Clara wanted Eduardo prosecuted for his abuse and also wanted the family court to grant her custody of Lupe in the divorce case, but she was afraid of what Eduardo would do if he learned about it, which form would be most protective of Clara? And you've got the U visa, the VAWA self-petition, or the T visa.
Mary-Kate, do we have the place where people can vote? There we go. And this is a multiple choice, so you can click all that apply.
Although the question does say which one would be the most protective of Clara.
That's true.
I'm getting flashbacks from the bar exam.
Sorry.
Their questions. Somebody thought that was funny. I'm glad.
Yes. So we see, is it possible to show the results live? Or I don't know how that all works. Okay, so about 80% of you said self-petitioning, 26% the U visa, and 14% the T visa. So should I go ahead and process this, Jane, or do you want to? I can.
Oh yeah, why don't you take it?
Sure. So what's interesting is that they're all equally protective. One could argue that maybe the self-petition is a little better because it moves, you get your prima facie determination faster, but the VAWA confidentiality protections technically apply the moment it's filed. But the reason but the other point to make is that Clara, because she's married to Eduardo and he's abusing her, is eligible for protection from some of the VAWA confidentiality provisions just by virtue of the marriage to an abuser. You don't have to wait to file. But when we talk about discovery, obviously we're talking about a case that got filed, and the discovery protections apply the moment anybody files. And they're all the same, basically. Back to you, Jane, I think.
Okay. So tell us your experience. Do you see, and I could already tell in the chat that a lot of you do, cases where the abuser, the trafficker, or the perpetrator has in a criminal case sought discovery, or I guess it wouldn't necessarily have to be criminal, that's just where I default, has sought discovery of information about what is contained in that immigration case file. So I'm going to just guess that most of you are going to say yes to this based on the chat here, but I do think we have a poll. Oh, I've got it. Wow, it's running 50-50 about.
Yeah.
Okay.
Great. So want to show the poll? So we got about 60-40. So it's actually 40% of you are actively seeing this, and the rest of you have not yet, but that certainly doesn't mean that you won't. Okay. Great. So now we're going to move on to kind of getting in a little bit into the more of the meat of the VAWA confidentiality protections. And I'm going to talk to you a little bit about their history, purpose, and some of the key factors related to them. Get the next slide. There we go. So the VAWA confidentiality protections protect all information about a victim's VAWA confidentiality protected case. So it's not just what's in the file. It prohibits disclosure about even the existence of the case. So sometimes the perpetrator will just want to know, did they file? And that's not discoverable. That's not, DHS can't reveal whether it exists or not. They can't confirm or deny and whether the case exists. Also, information about decisions made in the case are not discoverable, and all of the information contained in the victim's, what it's called an A file, that's the immigration case file. The prohibition is to all persons, not just the perpetrators. So even immigration enforcement officials that work for ICE and civil and CBP, the Border Patrol, they can't see these files. What they see is a big red flag on the case that says hands off, essentially. A victim has filed a case, and they're it triggers them having to go through a whole bunch of hoops if they want to try to do any part of an enforcement action against a victim once the case is filed. And they protect survivors. It protects a whole range of victims. People that are victims of battery and extreme cruelty, which is the domestic violence definition and child abuse definition under immigration law, human trafficking, sexual assault, stalking, and that entire list of other crimes I showed you in the beginning. And the protections apply from them. The protections apply in terms of the discovery protections permanently from the moment the case is filed forever. Like it never ends unless the case is denied on its merits and all appeals have been completed. So if somebody files a case that is denied because they don't qualify or they fraudulently tried to get the case approved, if it's denied on its merits, then VAWA confidentiality ends. If it's dismissed because they get their green card some other way, VAWA confidentiality continues forever. Same thing as if the case was approved and they proceeded that way. So as background, VAWA confidentiality has 3 parts. Today, we're going to be digging deeply into the 3rd one in red. But I want to describe the other ones briefly because I think they help you understand, especially if you're going to be responding to discovery requests, why this isn't discoverable. Because it's all part of these 3 prongs work together. So there's a bar on the Department of Homeland Security, the Department of Justice, or the Department of State taking any action against a victim based solely on information provided by their abuser, their perpetrator, their trafficker, or family members or associates of that, that person, and somebody that it goes even farther than family members, and it applies to all victims. And what this means is these provisions are the ones that apply the protections against relying on perpetrator provided information in cases of spouse abuse, child abuse, and elder abuse perpetrated by a child against a parent. Those 3 types of cases, the moment you have the parent-child relationship, the step-parent-stepchild relationship, the marriage, those protections against relying on perpetrator provided information go into place the moment there's abuse and then those relationships exist. So it's before filing. So in those cases that this bar applies before filing because they want it to apply as soon as possible in the relationship. In U visa and T visa cases that are not spouse abuse, child abuse, or child perpetrated elder abuse against a parent, then it's when the victim is in the process of filing their U or T visa application. And usually that means as a practice point as a lawyer is that they'll give you, it's a good idea for your lawyer or the advocate to give you a letter saying, I'm in the process of filing. So if the perpetrator is, or the trafficker or the sexual assault perpetrator is trying to send Department of Homeland Security people after the victim, they can show them the letter, which has the effect of making them stop and go seek supervisor approval before they continue. So it's another way to kind of stop them in their tracks while you're getting your case together. There are locational protections. So there are certain areas like courthouses and shelters and transitional housing programs and rape crisis centers and, various victim serving programs where DHS can't do immigration enforcement. And then there are what we're talking about today, the non-disclosure provisions, which basically mandate that, the information contained in or about actions taken in the VAWA confidentiality protected cases cannot be disclosed generally by DHS, DOJ, Department of State, or anybody they give the information, the information to. And we'll talk about how that is moderated, and to the extent it's moderated in some criminal cases under some circumstances. Any violation of a VAWA confidentiality, each VAWA confidentiality violation is a $5,000, sorry, I made it bigger, fine for the individual, and or disciplinary action. There's enforcement policies, and this 384 flag is the red flag I was talking about that they put on the cases. And just so you know, immigration enforcement officials have to certify before the immigration judge in any proceeding in which any of the information they relied on to bring the person to immigration court may have involved any information from a perpetrator. They have to certify that they've complied with VAWA confidentiality. Judge Weir, back to you.
Okay, so you might wonder, why are we telling you about legislative history? What does that have to do with discovery? Well, we're telling you it because it shows how important Congress took this, how they recognized that the need for these protections, and that you as attorneys can and should use it to argue and to educate the courts regarding these protections and why these protections exist. Because if you look at the history that we're going to show you, this was Senator Biden, who obviously is now the president. This history shows us that these protections are there to prevent the accused batterers from using the immigration system against the victim. Once again, you might say, it might have been used in the past to threaten them. And now the victim is availing herself of the protections that she has, and he wants to use it against her. And we're putting this out here because Congress took this seriously. They recognized the abuse that immigration abuse, both the threats that you'll see in the next slide from Senator Kennedy, who talked about recognizing the prevalence of the threats abusers make, which trap the victims in these relationships. This is powerful. It also recognizes the barriers of immigrant victims, culturally, language, and their immigration status. So this is important for you to, if you're having to respond to a request for discovery, I think that's very important to include.
I agree. There's not a lot of strong case law in this regard. And so many of your arguments as a practitioner are going to be based on what is the legislative history, what is the public policy, why is this in place? And so this is an excerpt from the Honorable John Conyers Jr., who says, threats of deportation are the most potent tool abusers of immigrant victims use. And so we don't want to be helping the abusers continue to silence and maintain control over those victims. And that's what you want to articulate to the court. And furthermore, this is a bipartisan history back from 2005, where the committee says that they wanted to ensure that immigration enforcement agents and government officials are not relying on information that's being furnished by the abusers, by the offenders, to detain or attempt to remove victims, because of course, they are going to continue to try to manipulate, control victims, even those who have tried to exit the relationship. And one of the strongest tools they have, again, is perhaps to try to get this victim deported. And so we don't want our government relying on those abusers to for us to be a tool of their further abuse.
So this is a full list of all of the immigration cases that get this VAWA confidentiality protection. So the VAWA self-petition, cancellation and suspension, which are the two forms of relief before the immigration judge, the battered spouse waiver, U visas, T visas. There's a particular form of work authorization that abused spouses of certain employment visa holders get. It's the A, E3, G, and H visas. Those are protected, as is continued presence for trafficking victims. And one of the things that's important, particularly for the judges on this call to know, on this webinar to know, is that, and this is similar, I think the patterns are similar from, this is data around U visas, but I think the patterns are similar for self-petitions, and Jane, you can tell us whether you think it's similar for trafficking victims, but 91%, over 91% of the cases filed, the immigration cases filed, are filed with legal representation. Now, for those of you that are victim advocates on the call, it's important to know that the forms are set up. So if even victims that are represented by lawyers, there's a place on the form where the person who assisted the victim in preparing the case, that could be the victim advocate, that like if you have a victim advocate and a lawyer working together, if you list, but if the lawyer puts in a G28, which is the legal form, and the victim advocate puts their name on the self-petition or the U visa, it's really important because that tells USCIS that these are both safe people that they can communicate with about the case. If the victim advocate doesn't put their name on the case file, and let's say, and then you see there's a small percentage of people that file only with assistance of victim advocates. This happens most often in more rural communities where there aren't lawyers who know how to do these cases. And NUAP provides technical assistance and support both to the lawyers and victim advocates who are assisting victims. And about 2.8% of the victims file on their own. And one of the things to know about VAWA confidentiality is because of these protections against discovery and release of information about these cases, if a victim files their own case and wants to inquire about the status of their case, there's absolutely no way to do it for that 2.8% except snail mail, except for like old-fashioned US Post Office mail, so that the USCIS can match the address and the signature. But if you have a victim advocate on your form and a lawyer who or a lawyer represents you, the victim advocate or the lawyer can call, ask the information, and they'll match that name and that agency with the case that's filed and decide whether they can safely respond under VAWA confidentiality.
All right, so we're going to do another poll here. We want to know your experience. Have you had a case where the abuser, the trafficker, or the perpetrator sought discovery of information about or contained in the victim's immigration file?
I think that's the one we just did, right?
Well,
a little bit different.
We did it. It's a little different.
Oh, okay.
And Mary Kate, do we have the poll? Yes, people can put yes or no in the
Hi,
chat.
sorry, I'm looking and I think we have the poll, but I don't know. I'm looking and
We can just put
think
yes
I
or
might
no.
have
People
gotten,
can,
yeah.
Let's go to the next slide if you can,
the
because
next
that's
one.
also a poll for if you did answer yes, what kind of cases? Were they criminal, family, civil, all of them, other?
Okay, and this one we've got some great.
And if it's other, can you write in the box what the other case was?
And while we're doing it, somebody asked to repeat on the, I believe, I don't know, Rocio, maybe you can type in the chat exactly what page of the form where the victim advocate can put their information. I think it's the front page, but I can't remember exactly.
Okay. Okay, so it looks like mainly we're seeing these requests made in criminal, family law, a civil employment case, there's one, and some others, which we're not real sure what they are.
I think we
But,
see protection from abuse is one of them.
Okay, so PFA and order of protection. Okay. I actually saw that a lot in order of protection cases, both as a lawyer and I see it as a judge attempts to obtain that information. So if we can go to the next slide, what are the, oh, I've got the
This
poll
one?
still up. So what types of information do you think might be in that victim's file? If you represent the victim, or if you're representing the victim, do you give the victim a copy of the entire file to keep? I think these are, since we can't answer, just some things to think about. Or if you're the immigration attorney, do you keep it? Do you think there might be more protections if the immigration attorney kept it versus providing an entire copy to the individual? And you can go to the next slide. The reason we ask this is you should understand what is in these immigration files, because it really is a plethora of information. There's a lot of stuff in there that you just don't want to willy-nilly, hey, we got a request, I got to turn it over. That's what we're here to prevent. Is this really information when you look at this list of things that we want the better to have? Is giving this away consistent with the protections that are afforded under VAWA confidentiality? So it's important. This is why we're here. This is why we're discussing this, because these are not things that should just be handed over, and these are things that Congress meant to protect.
Exactly. And there's a note in the file, or somebody's commenting on the use of term victims versus survivors. We use them interchangeably in training law enforcement, and Jane, you can comment on prosecutors. We find, and judges to a certain extent, victims resonates more in terms of people are more, you sound a little bit less like an advocate. We understand that people who are survivors might prefer to be called survivors, and that change is happening. I mean, Mary, you can comment on to the extent, Judge Weir, you can comment to the extent that that change is happening with judges, but we tend to go back and forth and use the terms interchangeably when our audience is judges, prosecutors, and law enforcement and victim advocates. Jane, anything you want to weigh in on there?
Yeah, I agree. I think Julie put in the chat as well. There's a legal significance to the word. So in certain settings, it just makes a lot more sense. But I always, when I train folks, make sure that when we are interacting directly with survivors and we're talking to them about processes, that we have conversations about language and why we do what we do. So transparency usually is the key to that.
Yeah. So what I'm going to do now, talking about transparency, it's also important to know what the exceptions are and how they're supposed to be used under VAWA confidentiality. And so there is a law enforcement and national security office officials exception, but that exception is solely for legitimate law enforcement and national security purposes. And the regulations and policies by the Department of Homeland Security require that they inform the law enforcement or national security official to whom they give the information that it needs to continue to be protected by the they have an obligation to continue to protect the confidentiality information. So this is not the exception through which police or prosecutors may be able to get VAWA confidentiality protected information. Similarly, let's do a true or false question. So the question is, and I believe Mary Kate has a poll for this one, that VAWA confidentiality's judicial exception, does it apply to state court judges hearing criminal, family, or civil court matters? Mary Kate, do we have a poll? Great. So if you think if you think it applies to state court, put true. You think it doesn't apply to state courts, put false. Seeing about half of you, a little over half voted. Give me a few seconds more as it's coming in rapidly. I like seeing that. Okay. I'm going to end the poll and share the results. 75% of you say true and 25% of you say false. The answer is false. And let me explain why. So the judicial exception, and there's a case that we'll be discussing later. The first case on this was the Hawk case. There's now DHS policies on this as well, that the judicial exception applies only to judges hearing appeals of the victim's immigration case file. The Board of Immigration Appeals, a federal judge that may hear an appeal from a denial from the immigration judge or the Board of Immigration Appeals, those kinds of things, the Administrative Office Review, AAO at the department at USCI, at U.S. Citizenship and Immigration Services. The exception does not extend to state or federal judges hearing civil, family, or criminal court matters. And the Hawk case really summarizes it. This was one of the first cases that challenged this, where this was adjudicated, and ultimately regs and policies have adopted the position that the Hawk case court laid out, which is that it applies to all cases unless they're denied on their merits. The judicial exception is for the victim's immigration case. The Sixth Amendment right to compulsory process does not permit and access to absolutely privileged information. And the primary purpose of VAWA confidentiality is to prohibit disclosure of confidential information, particularly to the accused batterer who was seeking it in the Hawk case, and who is often the one seeking it in the family court cases, and is often the defendant seeking it in the criminal court cases. There's a few other benefits. There's a limited benefit for purposes of verifying state public benefits like housing or TANF or food stamps, or other places where there might need to be benefits verification. It can be given anonymously to Congress for oversight purposes, and the victim can authorize, and in this case, if there are multiple victims in a case, it has to be all adult victims have to agree to authorize the waiver of reality. That's something that very, very seldom happens. So now we're going to move on to digging into more about the discovery requests themselves in state court cases. So how do VAWA confidentiality and discovery issues come up in family court cases, Judge Weir, from what you've seen?
What I've seen is, I've seen it in custody cases, and I've seen it in order of protection cases, or protection from abuse cases on the stand when the victim is testifying. So different lines of questioning. I've seen discovery requests for production of documents, and I haven't had it, but I've heard it coming up in depositions.
And go ahead.
So is it relevant? So how do we deal with this? So in a family court case, how are we going to address this? So to be admissible, evidence has to be relevant. And we think of this as logically relevant. Does it tend to make the existence of a fact more or less probable? Generally, what we're hearing in family law cases or custody cases or order of protection cases, we're hearing she's lying. This is a motive. This is her motive, is just to get her immigration. It's not true. So then we have to look, is it legally relevant? Well, to do that, we're weighing the probative value versus the cost to the victim. Is there prejudice? Is it going to confuse the issues? Or is it going to mislead a jury? Now, in most family law cases, I think except Texas, orders of protection and custody cases are tried to the judge. So we don't have the misleading the jury issue there. Confusion of the issues. Well, I guess that goes to how educated is the judge on immigration abuse, on immigration relief, on VAWA confidentiality. Is it relevant? Is a motive for lying relevant? I think a lot of people are going to say, yeah, that's probably relevant. Is the court going to get confused? Is the judge going to get confused? I never worried that the judges I was appearing in front of were confused, because I think in most of the cases they got it. They understood the right to immigration relief. So I never really ran from the question when I was practicing. But, people have different ideas of how this plays out.
And in the end, there's a balancing test. It's that you want to look at the prejudice or the harm, or how you may discourage the victim from coming forward and using the courts. If these kinds of questions come in, are those part of the analysis too, Judge Weir?
Yeah, they definitely are. And I think what we see is some limitations that play out, that you may allow. Okay, I'll let you answer the question. Have you applied for a U visa? Okay, go ahead, answer the question. That's it, you're done, move on. Some judges may allow it to go further. Would I allow it? Question on the stand. I certainly, if I get an objection, I'll listen to the objection. It's not for me. I have to hear the objection. So it's not for me to insert myself in that case. So it is up to the lawyers to provide the objection. If I don't get an objection, sometimes the victims will say, well, why is that? Why do I have to answer that? Well, I take that as an objection if they're pro se. And I may or may not allow it. If they're actually seeking documents, the only thing I've never allowed anything in a family law case. In criminal cases, you're going to hear more from Jane on that, about what is to be allowed and what isn't. But I have allowed people to ask the question, or to ask the question and allow the witness to answer regarding whether they've applied. Now, sometimes it's been argued her status is relevant in a family law case, because if she's going in a custody case, because if she's going to get deported, the children can't be deported. So I've had attorneys turn around and say, listen, yeah, she's got a U visa. She's not going to be deported. We're willingly going to admit that. That doesn't open, in my opinion, and I think in the case law that you'll see, does not open the door. Well, she told us she has one. We should be able to get the file. We should be able to get all the records. I don't believe that constitutes a waiver to the court. So, I didn't fear the question when I was a lawyer. I think you need to know your judiciary. I think you need to educate your judiciary on it as well.
And I'll just pick up on that point. We have just published yesterday a kind of like a little how-to guide on step-by-step how to respond, and that it includes in there links to, like, we have a sample. These were actual amicus trial briefs that we filed, or amicus trial briefs that we filed in trial court, and one of them was in a federal district court, one criminal and one family law. So they're kind of the arguments are out there for you, and you can adapt that trial brief into a motion or something like that, so that the law we have in the materials from the webinar all laid out for you to use, so that you can educate a judge that may not be as knowledgeable as Judge Weir was by the time she got to the bench on these issues. And so generally speaking, the case law is pretty consistent, and we'll go into the details of some of it, that in the family law context and largely in the civil law context, and certainly with VAWA self-petitions, nothing's discoverable, because there's no, as Jane will explain in a few minutes, there's no government involvement, there's no certification, there's no, it's just the immigration file that nobody has custody and control over except DHS. So anyway, I'm going to go to the case law for you, Judge Weir, and then we'll go back.
Yeah, and I do think it's really important to remember if you're appearing in front of state court judges, we don't do a lot of immigration work. Okay, so it's important to educate us. There is nothing wrong, and frankly, we appreciate it. We are not all knowing, and there is nothing wrong with saying to the judges, as you are well aware, this is what VAWA confidentiality is. This was the legislative history. Or saying, Your Honor, I've briefed this issue. I don't know if you're aware, but I have briefed it. And 99 out of 100 are not going to be. We appreciate it. We appreciate you providing us with that information, because that's not something that we get in Judge School 101. We don't learn a lot of this. We don't. So this is a great case, Dimaj. This is out of Connecticut. This started as a Hague case, a Hague Convention case. The parties had lived in Italy. The husband was in Italy. Wife came to Connecticut. He files a Hague petition saying she's taken the children. He eventually files it. He didn't file it right away. He files a motion to compel the production of documents. That was his, that's what he wanted. His ask was that he wanted the documents because to address his wife's use of the well-settled defense in the Hague case. He said the documents will include the allegations of abuse that he will use in his case to impeach her by questioning the credibility of any testimony she may provide at trial. So what the underlying court did is they gave, well, the respondent admitted, hey, we've given you some documents. They've given them visas and social security cards, authorizations to work. They produced that, but they withheld the other documents claiming VAWA confidentiality and attorney-client privilege. They also said they're not relevant to this case. So the Dimaj court said, okay, you're aware the existence of the U visa, fine. The court noted and I thought this was interesting when you read Dimaj, the court notes that the mere application that the husband was seeking, well, that's not going to entitle somebody to a U visa. Just because you file an application doesn't mean that you're going to be granted a U visa. So the court noted that, and I thought that was important. They also stated that while the claims in the application may be relevant to impeach the wife's testimony at trial, that disclosure runs contrary to the public policy. So in Dimaj, they said that allowing these documents to be disclosed would assist the perpetrator in interfering with and undermining the victim's immigration case. So they did not just allow these to come in. Basically, they said preventing disclosure of these documents would allow, or by allowing the disclosure, it would allow them to interfere with the immigration case. So that's everybody recognizes credibility. Everybody recognizes impeachment. You can go ahead. You're not getting the documents in a civil case. That's what Dimaj was saying, that preventing. Well, you may be able to ask about, does it exist? Because it may be relevant as the status. You're not getting the actual documents.
Right. And what's interesting is we have a whole other training. We can send you the link to it. We did a training on custody where we put forward all the data about who really gets removed across the last like 8 or 9 years. And you can see that most of the time it's people with criminal convictions, and that many of the victims who come to court in family court cases are not victims with criminal convictions. So that even if she's undocumented, you can counter those things. I'm going to skip ahead because I wanted to be sure Jane has plenty of time to talk to the prosecutors on the call. So I'm going to skip to how this comes up in civil court discovery cases. And the preeminent case, most of the civil court discovery cases that get reported are the civil court issues are employment cases, often brought by the EEOC. But the other types of cases that this, and the civil side that this can happen in might be a tort case of a victim against her trafficker, sexual assault victim, survivor against their perpetrator. It might also be, there might be a landlord-tenant case where the landlord sexually assaulted the tenant in, the apartment. I mean, there could be those kinds of cases where they can come up. In the civil context, it's very similar to the family law context. And this Koch case, the EEOC versus Koch case, is useful in all contexts, in civil, family, and criminal cases. They dive deeply into why the VAWA confidentiality discovery laws were written, and how in civil and family court cases, but they're focusing mostly on civil, the court has to balance the purposes of VAWA confidentiality against the need for the employer to get the information and the relevance of it. And that they only allowed, basically in a multi-victim sexual assault employment case, they allowed discovery only. Ultimately, they told the court to recraft the order, and what the district court did is allowed discovery only of anonymized certifications that the EEOC had signed for the victims. And it's got really good wording. The COCAT has really good, useful wording.
Well, and it also, one of the things about Koch, I mean, they really focus on the chilling effect that disclosure would have, not just on the individuals that were involved in that case, but as to the whole public policy of VAWA to protect these records. So I think that's important. And also, they did in this case, as they did in Damage, they talk about the protections afforded by the U visa process itself as to the whole issue of fraud. So both of these cases, these federal courts are saying, really, the fraud issue, that's really for the U visa, the folks who are reviewing the applications. Well, it may occur, it may arise. There's a lot of protections out there, including deportation and taking away the U visa itself. So,
and that reminds me, Judge Weir, there was a question earlier on that I want to respond to. The question had to do with if the perpetrator or somebody is trying to call in and give tips to USCIS or DHS or ICE about the victim, what happens with those? And essentially that goes to that first prong of VAWA that I was talking about. They're not allowed to rely on perpetrator provided information or information of the alleged perpetrator. And so there's all these checks and balances in place that prevent that information from interfering in the victim's case within DHS.
And I just want to also point out on the EEOC case that while the court did not forbid discovery outright, they directed the judge to not only look at the chilling effect, but also to rely on the discovery process itself, and where we do weighting and the balancing test itself there to protect the victim as well. So,
and what's interesting is the other thing that Koch said, and then we're going to switch over to the criminal and talk to Jane a bit more, is Koch recognized and this is the highest court this has ever gone to, it's Fifth Circuit. Koch recognized that there's an interim effect and there's a chilling effect on the victim, on other victims. And by chilling victims, it impacts the ability of law enforcement to do their jobs and their own safety to a certain extent. So it really looks at kind of the broader purpose of VAWA confidentiality and does a very good job of articulating. So Jane, how do these VAWA confidentiality and discovery issues come up in a criminal court case?
So it's very common in cases involving immigrant victims for the defense to seek out this information. And I've seen it happen where the defense asks for the court to issue a subpoena to DHS, USCIS, or a motion to compel. I don't think, much like most of us probably, defense counsel doesn't really have a good grasp on these concepts either. So they kind of throw everything at the wall, sometimes trying to get this information. So as a prosecutor, we do have not only our obligations to follow the rules of discovery in our individual jurisdictions, but we have the ethical obligation to comply with the due process requirements of both Brady and Giglio. And so the case law is pretty consistent that the prosecution is going to be held to have care, custody, and control over certification request or a signed certification in a U visa case, if anyone has signed it. And so the certification itself is going to most likely be deemed discoverable and requirement to turn that over under due process obligations as well. So the real fight comes in when they want something other than just the certification or the request to certification. So what we're looking at is similar to what Judge Weir talked about, which is this information relevant? The courts have deemed that information to cross-examine a victim or witness in a case is widely found to be relevant. So the fact that the victim, whether we think this is their motivation or not as the prosecution, it will be deemed relevant in most cases if a victim, as a result of the victimization that you are prosecuting, has applied for some form of immigration relief. That will be deemed a motive to lie, a motive to exaggerate, a motive to curry favor with the government. Sometimes that's another argument to be made, and appropriate place for cross-examination. Now, there are some exceptions to that. What we've seen is courts will take into consideration the timing of the application for a U visa versus the timing of the disclosure of the victimization. So when it's very clear that the victim disclosed the victimization without knowledge of the U visa and didn't even apply for the U visa until quite a bit afterwards, so there's really not that connection, you may find courts that'll find that timing would make the U visa not relevant, or make it so that it is substantially more prejudicial on behalf of the victim than it is probative to the disclosure. So timing might be an issue. And the other place we find where courts have found, you know what, this really isn't relevant is when a parent has applied for a U visa because their child experienced the victimization. And in those cases, it's usually because the child is the one that's going to testify to the victimization, and the child does not have that motivating factor. But we also want to talk about public policy. I saw in the note, somebody was mentioning that states have recently, a handful of them, enacted specific rules of evidence which say, hey, immigration status is not relevant in civil and criminal cases. But there's usually exceptions to even those statutory rules of evidence. And those exceptions usually are when there's a criminal case and someone has actively sought immigration relief. So this is something that I know NUAP and I have been diving into recently, trying to figure out, okay, what is the case law out there? What have the states done to try to protect immigrant victims of crime? What it falls down to typically is the certification, the request for the certification, or the declaration in a T visa. Those are going to be discoverable, but the rest of the file would not. And that's kind of what that next slide talks about as well. So first off, the instruction is that if anything is turned over, it should be in a manner which protects the confidentiality of the information. But then there is the other note, the side note that says defense counsel in state cases may sometimes attempt to make the entire A file discoverable. That's the entire immigration file that sits with DHS or USCIS. And this says particularly, however, the entire file is not discoverable in its entirety under this exception. And I think this is, those VAWA confidentialities and how they interplay. And this might be in criminal cases. This is a little bit of a deep dive because you'll hear in criminal cases, courts are really going to separate themselves from maybe some of these regulatory rulings. And of course, we should be using them because it helps educate, it helps frame the issue. But you're going to have judges much more likely to rely on things like prejudice to the defendant, due process rights to the defendant. So it does say here that agencies receiving information under this section, whether they're governmental or not, are still bound by that confidentiality. So someone in the note said, what if we give it to the judge, gets it in some way, and that judge then writes a ruling about that file, and then that ruling exposes the file to the public, much less the defendant. And so those are cases where, prosecutors should really be taking a step back from sometimes our default. Our default is, open file discovery, or sunshine law is what we call it in Florida, which is like, you're never going to get in trouble for giving everything you have or to making sure that the defense has access to everything in the file. And this is a place where we want to be a little bit more cautious with our general, kind of go-to, which is, oh, they can have it, we'll deal with it in pretrial motions. We have to be more careful here because the confidentiality and what DHS tells us about the confidentiality is so much more heightened than anything else. But typically a good argument, I put it in the chat, is we don't even have access to that information. It's not in our care, custody, and control. DHS, USCIS is not going to be deemed part of the prosecution team like our local law enforcement who may have signed the certification. So those are some of the arguments we'd make.
So Jane, what about, can you explain what, let's say I'm an advocate and I'm starting off and I'm doing a U visa case and I want to be sure you, Jane, sign my cert. So I decide I'm going to give you the kitchen sink. I'm going to give you my application and my affidavit and the psychological record so you could see how harmed my victim was. What happens to that if I do give them to you?
It would become discoverable because now it is in my care, custody, and control. And I did see that especially early on as I was the certifier in Miami for all the misdemeanor domestic violence cases, and then of course all the related U visa requests. So we saw that a lot. Now quickly, I think there was some education amongst the immigration attorney sort of world. But yeah, because you're trying as their attorney, as their advocate, you are advocating for me to sign that certification. If I don't sign it, you do not pass go. You cannot apply on behalf of your client. And so in the go-to as an advocate was, here's all the reasons you should sign. And they would give me additional information to help me think. And of course, I wish I knew then what I know now about the U visa process, because I think I was a little bit harder than I needed to be on. I'm not sure about this. Was there real harm? Now I know as a certifier, I don't need to certify harm. That's the advocate's job. That's the immigration attorney's harm. So, but as soon as it came into my possession, it was in fact discoverable. So some of those, that information that really should be privileged and confidential became discoverable. So having task force meetings, talking with your community, if you're in a community where it's the same immigration attorneys that are working with you, let's figure out like what I need and what I don't need. And frankly, all that I needed was, it says cover letter. I might not even need a cover letter. Just give me the certification and some information about your client. Maybe you have the file number or something. That's all I need. I'm going to pull my own file. I'm going to ask the police for their files if I need to. And that's how I'm going to make my decision to certify or not. And that certification standard is reasonable suspicion. So it's a pretty low standard. So I don't need to have all of this information, and it just doesn't do any good service at the end.
So Jane, what if you didn't what if you weren't the certifier? What if a judge certified?
So if a judge certified, and we've had that conversation, is that going to be deemed within my care, custody, and control? And I don't think it would be, especially if it was in, you know, a collateral case, a protection order case that happened to go along with my case. But I'm guessing that if it was in that case, then the defense would know where to go for it. I wouldn't be beholden to turn it over. But if I had it for some reason, because we're working really collaboratively, of course, I would just turn it over. I'm not concerned about the certification being turned over. I kind of feel like that's my responsibility to that extent. And I think one of the things that comes up a lot when we train prosecutors is they're like, well, I don't want to certify now. I'm going to certify when it's all over, because I feel like that's protective of my case. But if you think about where that ethical obligation arises, it arises as soon as someone asks for the certification, because that's where the motive comes from. If you're going to see it through that lens, not when I sign it. So you don't do anybody any good by getting a request and putting it off, because you still have to disclose the request, and you have a vulnerable victim who does not have the protections that they are legally afforded under the U visa. And I've been defaulting to U visa, but most of this is really analogous with your T visa as well.
Yeah.
Okay,
So
so are we, oh, I think I answered this question. Sorry,
Okay.
guys. Spoiler
Let's
alert.
see what the audience took away from the question. So are the state and local required to obtain information from the federal immigration case? You voting? And I just want to note, there's a note in the chat while people are voting, is that Catherine mentions that they, you know, basically asked a question about whether the declaration would be discoverable only if you turn it over to the prosecutor. If it's in the victim's U visa or VAWA case, it's not discoverable. In the poll, share the results. So, Jane, you want to process?
Yeah, so it's no. It gets a little bit messier if you're working maybe a trafficking case and it's a federal prosecution. But if you're in a state and local jurisdiction, it would not be discoverable.
Great. I think, Jane, this is still you.
Okay, so the protections prohibit the disclosure of information, but state and local prosecutors are not constitutionally required, and they actually do the analysis under that Brady line of cases to either seek out, obtain, or disclose the existence of any information in the federal immigration case files.
So, Judge Weir, how should criminal court judges respond to requests from defendants for the victim's file, given what we're talking about, and how do you handle these when they come to you?
Well, I think they're entitled to, in a criminal case, as Jane has said, they're entitled to the cert if the prosecutor has that. And they're allowed to cross-examine on these cases. If you on the U visa or T visa, if you want to go to the next slide,
Mm-hmm.
this is, in this case, the they didn't disclose, and they basically they wanted a lot. They wanted the entire file from the immigration attorney. First, they wanted it from USCIS, and their subpoena was not in good form. Then they went to the immigration attorney. They wanted the whole file. They noted there was a fishing expedition, and the court said it was not error. They were aware she was submitting the U visa. They got the certification from the prosecutor, and they still were allowed to cross-examine the victim. And that was enough. That was enough to protect the constitutional right of the defendant in that criminal case. And then on the next one, on this case, they found the whole issue to be tangential. It was a collateral issue. This person did not know, as Jane talked about timing, this person did not know, the victim did not know about the U visa until after she had called 911. And then I believe she may have been in the emergency room or receiving some type of, she was in the emergency room having a sexual assault exam. And then, so they basically said it was irrelevant to the case. So they did not allow it. So the timing is a big one, and you can rely on this case related to timing.
Okay.
They excluded all reference to it.
Great. And so, like, when you talk about how these differ, the VAWA T and U visa cases, so the main ways they differ is in U visas, you will always have to have a certification. So if the certification was in a protection order case from a judge, or in a child custody case or a child welfare case that has nothing to do with the criminal prosecution, then there wouldn't be discoverable even in a U visa case. If, as Jane was talking about earlier, if you have a trafficking victim case, a T visa case, there may or may not be a declaration because it's not absolutely required. So if a declaration was issued by the prosecutor or the police, then it would be discoverable just like the cert in the U visa case. VAWA self-petition cases are totally different because there is no cert and there's no declaration. There's no role for a government official to do or sign anything. So my view is that in VAWA self-petitioning cases, even criminal ones, there's nothing discoverable because there's nothing that would ever be in the care, custody of control or control of Jane, the prosecutor, unless some victim advocate gave it to her or a lawyer gave it to her, which they shouldn't do. So that's kind of how they differ in terms of these discovery things that we've been talking about. So in terms of the depositions, I think Judge Weir, you mentioned this. Jane, and you had said that in criminal cases, there aren't that many states that even have depositions. What I'll say from the, Judge Weir, if you want to weigh in, you can let me know, but what I'll say from the TA that we do, we often get attorneys calling us before they walk into a deposition when they suspect or there's been, that they're going to be asked. And what we say to do in a deposition is, quote, say, I'm not going to answer that, and then quote, VAWA confidentiality and state the law, and then make it go to a judge and then brief the judge. Judge Weir?
Exactly. That's exactly what you should do. You can either file a motion before the deposition to limit or exclude the questioning, or you can stop the deposition, or not stop the whole deposition, but refuse to answer that question, cite your reason because you are with a court reporter, and then you can file your motion afterward. And really, you should know, you're probably going to know this ahead of time, especially if you're in a family law case, because I know as a lawyer, I always heard it. The chatter was the other side is going to say that to you. So you can anticipate it. If they never mention it, that's probably going to be a big surprise, because they usually look to, I don't think I ever had an immigrant victim client where they didn't try to raise this in a
Mhm.
family law case. So
Exactly. And
Yeah.
how might,
Just
Jane
listen to the
and
chatter.
Judge Ware, how might expert witnesses be helpful on these, around VAWA confidentiality and some of the issues we're discussing to a family, civil, or criminal court case involving an
well,
Yeah, I
I
think
think
Yeah,
you
Go
go
ahead.
ahead, Jane.
I would just say, I think they can be incredibly helpful. I always like to make sure folks don't think of expert witnesses only as testifying experts. You may want to engage an expert witness so that you can better make arguments and better frame your cases. But there is also case law that allows for expert witnesses to talk about what a U visa is, what it's not, what a T visa is, and that can be very helpful because the underpinning rule of expert witnesses is can it help the jury understand something that is, relevant to the case, and is it something that's outside of the general knowledge? Well, I think we're all on this call recognizing that this is not only outside of the general knowledge of our jurors, it's often also outside of the general knowledge of judges and our defense counsel and even ourselves to a certain extent. So experts can be great to engage with, to educate ourselves and to educate the court and a potential jury panel.
And frankly, if you can't afford an expert witness, say you're in a family law case and you can't afford, go to your local shelters. They usually are going to have people who will be qualified, that you can qualify. Therapists often have testified in both criminal and civil case, family law cases in our jurisdiction, and they have come from the shelters.
And if you have an immigration lawyer or a family lawyer, somebody who's going to talk about VAWA confidentiality, for example, as an expert witness, one of the things you want to be sure to do is don't call the immigration lawyer that represented the victim in the immigration case. Get somebody else, because that'll just muddy the waters and you don't really need to go there. And I know we're coming up on the end of this webinar, so I want to be sure to summarize here as we close. We have a couple of things we want to tell you, and we have lots of materials and resources that you'll be provided in an email following the webinar that are on the webpage, the link that we gave you. You can, we'll send you a link to this webpage. There's for judges and judicial officials on the call, court staff. There's a whole toolkit for state court judges. It's also useful to family lawyers that will link, and you can always call us for technical assistance. And if you're a prosecutor, we'll connect you to Jane or one of our other prosecutors. If you're a judge, we'll connect you to Judge Weir or one of our other national judges that does judge to judge TA. And then family lawyers, I can answer the questions, and we have other family lawyers and immigration experts that you can reach. Judge Weir?
Yeah, if you're on here, you are a judicial officer, I would encourage you to join the National Judicial Network. It was formed within, I guess, the last year, and it has, it's just primarily, it is judges. It's an opportunity to speak to your colleagues throughout the country, to connect with them. There are peer-to-peer sessions and webinars. It's a wealth of information, and it's free, no membership dues, and I would encourage you to join.
And we also have Jane.
Yeah, we have these virtual roundtables. It's usually me and Detective Michael LaRiviere, who's been doing this work for a long time out of Salem, Massachusetts, and we'll host others, and we have interactive calls. It's limited to practicing law enforcement, prosecutors, and system-based advocates that work within those agencies. We talk about all sorts of things. It's an opportunity too to maybe have questions about more specific cases that we can't get to on a webinar like that, but we can actually kind of dive in a little bit deeper during these roundtables. So please sign up if you're interested.
And for many of you that are family law lawyers and victim advocates on this call, we have two communities of practice that we run. The family law community of practice are for family lawyers who work with immigrant survivors in their practice. VAWA confidentiality is definitely one of the things we often talk about, as all kinds of other topics. Rocio Molina, who's been staffing this call, myself and Professor Veronica Thronson co-facilitate the family law community of practice. and Rocio leads the, together with victim advocates, the Victim Advocate Committee of Practice that meets about every other month. So please do join us. It's a way to get ongoing continuing education through all of these, whether it's the judges, the roundtable, or the communities of practice. You can ask us to train you or get somebody to train you on anything you're interested in related to your work with immigrant survivors. And so we encourage you to join us. And I want to thank, please fill out the evaluations. The evaluation is in the chat. I want to thank Mary Kate and NCJ-FCJ for supporting this effort, Judge Weir for your great presentation, and Jane Anderson from Equitas as well. It's always a pleasure to work with all of you. And we hope this provides you, answered a lot of the questions that you were interested in. We'll double check the chat and make sure we get back to everyone and provide materials that answers all your questions that we may not have gotten to. And please call us for help as you run into these issues. We have brand new publications, updated case lists, and how-to guides that will be circulating. And anytime you have a VAWA confidentiality violation, call us for technical assistance. We do, that's part of the bread and butter of what we do at New App. So thank you so much and have a great weekend. Mary Kate, can we stay on a sec and debrief?
Yeah, sure.
I know people will be leaving.
And the interpreters can leave as well.
Yeah, exactly. You don't have to stop the recording.
Yeah.
It's just if we try to connect someplace else, it's like I lose everybody.